My uncle tried to steal my trust fund. He went to the bank, showed an amendment to my parents' trust, and told them I was incompetent. He tried to get the bank to hand over the account to him outright. He signed papers that named him as successor trustee. He said my parents had wanted it that way. He said it with a calm I could hear through the phone, and it felt like someone pulling a bedspread off a sleeping person. It hurt because that money was my life in slow increments. It was rent paid, tuition for a course I could no longer afford on my own, the balance that kept me from being kicked out when I was sick and couldn't work. It hurt because he chose to believe he could erase my right to what my parents left me when they died. It was less about the sum, though it was not small. The trust was stocked with nearly $650,000 and a house, and more about the idea that a man who used to teach me how to light a charcoal grill could so casually decide my future. I'm 32. At the time, I lived in a 2-bedroom walk-up in the neighborhood where my parents had raised me. The house on Elm Street was supposed to be ours until the reality of college bills and therapy and a poorly timed diagnosis made it impossible to stay. My parents set the trust up years earlier in 2012 after a sensible conversation with a lawyer they trusted. The terms were straightforward. My mother and father named my uncle Richard as successor trustee if something should happen to both of them. They named me as the beneficiary. The trust stipulated distributions for education, housing, and medical care, with a discretionary distribution clause for reasonable needs. That last phrase would become an argument. My dependence was obvious. After my mother died in late 2018 and my father in early 2019, the immediate practicalities fell to me and to who was willing to show up. I'd lost my job in 2020 and was on a wound-tight budget. The trust paid a modest monthly allowance to cover essentials, and it allowed me to live in the house on Elm Street. It covered mortgage and property taxes until I could get back on my feet. Richard was, for years, the family's fallback. He lived nearby, had retired early, and came by for dinner every second Sunday. He taught me to prune roses, and he knew the names of my childhood friends. Trust, in the way families have it, was a thing that accumulated in small gestures. That accumulation shattered when he walked into a bank teller's office and presented papers that claimed my parents had changed their minds. The setup was tidal. I couldn't simply leave or cut him off. The house had medical memories in its walls. My father's oxygen machine, the dent in the hallway from the wheelchair. And while I didn't live there full time, the mortgage payments were covered by the trust. If the trust stopped, the mortgage endangered. I had therapy I needed and a medication that cost more than the average monthly grocery run. I was already 2 months behind on the car insurance. I couldn't hire an expensive lawyer to fight a family legal war while my accounts were frozen. That created the imbalance. Richard had time, a network, and the ability to present himself as the reasonable steward of the estate. I had patience and a small fraying resolve. The first escalation came the day the bank put a temporary freeze on the trust account. He called me and said it was procedural, that he needed to rearrange things so that the house could be sold quickly and the proceeds distributed in a way that would be fair. He used the word fair like a blade, as if the only people who could be reasonable about this were the people moving money. My reaction was immediate and vocal. I asked why I hadn't been told. I asked why he had gone to the bank without talking to me. He told me not to worry, that I would still receive what I needed. He said to give him time. At the time, that should have been the first warning sign, but it was also the voice of my uncle, someone I had let in. Consequence: checks bounced. The landlord called and asked if I was having financial trouble. I lied and said it was a bank error. The situation got worse because Richard used that pause to call my sister, Tessa, who lives 2 states away, and told her the version of events he wanted to be true. He convinced her that I was overwhelmed and needed someone with business sense to step in. Tessa believed him on a telephone in November, when grief still made stories thin. The next escalation was more surgical. There was a new document, an amendment dated a month after my father's funeral. It named Richard as sole trustee with broad discretionary powers. It had 2 witness signatures and a notary block. When I asked for a copy, the bank gave me a photocopy with a faint photocopy stamp, not the original. Richard said the original was in his safe. My reaction was to ask questions of the lawyer who had drafted the original trust, a woman named Eleanor Park, who'd written the trust with my parents in 2012. Eleanor is precise and hates drama. She told me over coffee that if an amendment were valid, it would have been executed with the same formalities as the original trust. Same attorney present, same witnesses, same notary. That didn't happen. Eleanor said she'd look into it. Consequence: the photocopy continued to circulate. Cousins received it. Neighbours heard rumours, and an uncomfortable number of family friends assumed the trust change was real. The bank continued to treat the amendment as potentially legitimate because Richard had presented signed forms and proof of his identity. In the meantime, monthly distributions diminished. Money that had been earmarked for my therapy sessions came late or in smaller installments. The situation worsened as my small safety net frayed. Richard began to change the story in small ways. He told people I was unreliable, that I skipped doctor's appointments, that I couldn't manage money. He cultivated a narrative of concern. He started to show up at my apartment unannounced and to ask pointed questions about my medications and my job search. He found ways to make me feel small. An offhand remark about me being too emotional at family meetings. The way he reframed my need for therapy as a weakness requiring adult intervention. My reaction evolved into suspicion. I stopped inviting him to dinners. I documented everything in a notebook. Dates he came by, what he said, the people who could corroborate where I had been and what I'd done. I called Eleanor more often. She told me to stay calm and to gather proof. Her tone was practical. Don't let them outmaneuver you by assuming you don't know the rules. That one line clarified what I felt but couldn't say. Richard was trying to use process as a weapon to make legality look like order while actually changing my life. The next cycle of escalation involved the house. Richard insisted the house needed repairs and that selling it would be the most prudent course. He produced estimates, men in company shirts who said they could fix the roof, and a contract with a real estate agent he recommended. He said selling would free up cash for me to rent a place that would better suit my needs. He presented spreadsheets with numbers rounded in ways that made the sale look tidy. My reaction was visceral. That house was a map of my life. Selling it felt like signing away the only place that still had my father's handwriting in the margins of the cookbook. I refused. I asked that any decision be put off until Eleanor or someone neutral could review the estimates. Consequence: Richard moved to restrict my access to the house, citing liability. He said he'd do a walkthrough and would keep me informed. When I asked to be present, he told me it would complicate the inspection. He had a locksmith change the locks to the side door, claiming he'd lost the master key. I found out when a neighbor texted me a photo of a new lockbox number. The house remained in my name as beneficiary occupancy, but my physical access was curtailed. The situation worsened. I had nowhere stable to store my clothes, critical medical devices, paperwork. I spent a week staying with a friend, then a week in a motel. The fear that I could be shut out of my childhood home, the place tied to the trust that was supposed to support me, pushed me toward panic. There was a public embarrassment too. Richard announced at a family memorial that the estate needed to be handled responsibly. He arranged a meeting where he invited the bank officer and 2 family members. When I asked for the documents he was relying on, he passed me a sealed envelope and told me to wait until the meeting was over. I opened it later under the glare of a hallway lamp. It was a copy of the amendment and a typed letter that made me sound incompetent. The letter used the phrase unable to manage with the sort of legal politeness that felt like a punch. My reaction was to confront him. I called him and asked straight questions. He responded with calm evasions and a suggestion that my stress was clouding my judgment. And I remember sitting on the kitchen counter in my friend's apartment and sobbing quietly because every time I pushed, he accused me of being the unstable one. Consequence: more people took his side. The neighborhood grapevine is not kind to messy grief. I lost a few casual friendships because people didn't want to get involved. The "you should be reasonable" language got louder. The situation worsened as Richard accrued the social capital of appearing to stabilize the estate. Then things went quiet for a week. Quiet is dangerous when people are moving money. The low point came 2 months after the first freeze when a letter arrived that made everything feel real. A notice from the county registrar said a petition had been filed for a court-supervised sale of the house, initiated by the trustee, Richard. The petition included an affidavit asserting that sale was in the beneficiary's best interests and that I had been consulted. I had not. I had not been served notice personally. The papers showed a postmark from a different county. It was the kind of clerical error that could have been corrected, except the filing also asked for an interim management order giving Richard the authority to act in the estate's stead until the court could decide. The bank had not yet made a move on the money, but the court filing put a legal gloss on the idea that someone other than me could take control. I felt drained in a way that wasn't anger or fear. It was the quiet rinse of fatigue. I had just enough control to pack a duffel bag and sleep on my friend's pull-out couch. There was a moment sitting on the floor with my knees to my chest where I realized I had lost leverage. I had no independent funds to hire outside counsel. My people were scattered. The legal system runs on paper and money, and for the moment I had neither. This was the bottom: a stack of notices, a bank freeze that made monthly prescriptions spin out into late fees, a house possibly slated for sale I hadn't agreed to, and an uncle who moved through the world like a man confident he'd already won. The humiliation was quiet, about phone calls that I didn't answer because I couldn't bear to describe the smallness of my existence. The anger tasted like bile, the kind that sits in the throat with no clean way out. The turning point arrived because of a piece of paper and because my lawyer decided to move quickly. Eleanor managed to get me an initial consultation on a sliding scale. She listened without interruption and then said, "Your uncle has made mistakes. We can exploit the procedural ones." She didn't promise miracles. She asked me two practical questions. Who had physical access to the original trust documents? And who had been present the day they claimed the amendment was executed? I told her Richard kept the originals in his safe. I didn't know who, if anyone, had been a witness to the amendment. Eleanor's jaw tightened barely. She said, "We need discovery. Now." She filed a motion for emergency production of the original trust documents and for an interim restraining order preventing any sale of the house. The document that shifted things was ordinary. A work order from a local hardware company. It had Richard's signature and a date that placed him in a town 3 hours away on the day the amendment was supposedly signed. The work order had been copied and given to a neighbor who had been hired to do a small porch job. She didn't realize its significance until Eleanor's paralegal, Nina, found it tucked into a pile of receipts in Richard's mailbox while serving him notice. The mistake was that Richard had kept sloppy records and a paper trail that placed him miles away on the day he claimed to be at the hospital with my mother, getting her to sign a trust change. The work order had been faxed that afternoon to the company office and had a timestamp. The timestamp was the hinge. Eleanor didn't shout about it. She didn't declare a victory. She filed the evidence as part of an emergency motion to vacate the amendment on the grounds of improper execution and to appoint a temporary independent fiduciary while the court considered the matter. The motion laid out facts. The amendment lacked corroborated witness testimony. It was physically impossible for two signatures to both be authentic, given the work order timestamp. And there were irregularities in how the bank processed the photocopy. Eleanor requested a forensic handwriting analysis and production of bank records for recent transfers. Richard's face, when he realized his work order could be used against him, hardened in a way I hadn't seen. He called my phone once, then left a message with an edge I'd not heard before. He said, "You'll see how this looks in court." That was all. No threats. Are just a clear attempt to communicate that the fight had changed. Eleanor's plan was practical and quiet. She wanted to freeze the immediate risk, not make spectacle. The emergency order did that. The judge signed an interim restraining order. The house could not be sold. No distributions from the contested portions of the trust could be made. And an independent trustee, appointed temporarily from a list of local fiduciary firms, would oversee the trust assets until the court could make a final determination. Consequence, the bank's freeze became a court-ordered hold, which removed the ambiguousness of Richard's claim. The independent trustee audited and found irregular transfers to accounts associated with Richard's company. The trustee's audit was not poetic, it was numbers and timestamps. It showed 3 transfers in amounts between $12,000 and $35,000 that were labeled as consulting fees, made within a 2-month window after both parents' deaths. The consulting fees were paid to an LLC Richard controlled. There were invoices without file numbers and emails that referenced taking care of things. Eleanor used the audit to file a complaint alleging breach of fiduciary duty, conversion, and unjust enrichment. The complaint asked the court to surcharge Richard for the unauthorized transfers and to order equitable restitution. It asked the court to award me attorney's fees as part of the remedy. The complaint also requested a full accounting of how funds had been distributed since my parents' deaths. Richard's response was to deny everything, of course, but the small mistakes piled up. He had signed some of the invoices in his own handwriting. He had replied to an email with a sentence that said, "I covered it, expense paid." Those emails, when subpoenaed, became evidence. The independent trustee reversed one transfer because, as they reported, it lacked valid authorization under the trust's disbursement rules. My reaction to the court paperwork was muted relief and an odd tenderness. I remember leaving Eleanor's office with a copy of the motion and the audit, sitting on the stoop, and feeling that the world, at least for a moment, gave me something that felt like fairness. Procedure used as armor rather than blunt force. But the situation didn't resolve in a single paper. The escalation cycles continued. Richard launched a character campaign. He wrote letters to family friends and to a pastor who had been close to my parents, suggesting I was ill-suited to handle money and that I had been unreliable in paying for my father's hospice care. The language was precise and bitter. He painted himself as the adult who had stepped in to keep the family's priorities intact. My reaction was to keep documents and keep silence. Eleanor told me not to respond publicly. Anything I wrote could be used. Instead, she filed a motion to compel and ask for deposition testimony from Richard. The deposition was the second hinge moment. I sat in a corner of the conference room and listened while he answered questions. He seemed smaller under oath. He told the story he'd told in public, that my parents had been concerned about my capacity and had wanted him to be able to act on their behalf. Eleanor's questions were narrow and factual. When she asked him where he had been on the date of the amendment, he first said he was at the hospital and then, under subpoenaed phone records, had to acknowledge the work order admission that placed him elsewhere for an entire afternoon. His testimony became a tangle. Consequence, the court took the discrepancies seriously. The judge ordered the amendment set aside as invalid pending further review because the evidentiary showing suggested it had not been properly executed. The judge's order did not decide the full case, but it restored the status quo ante. The original trust stood, and the independent trustee continued oversight. That meant I could get back the monthly distributions needed for medication and rent, though they came under the supervision of the independent trustee who required stricter accounting. The consequence had a human edge too. At deposition, a cousin who had been friendly with Richard in the past admitted she'd signed as a witness for the amendment. She said she hadn't realized what she was signing and that she'd been told it was a routine form. What her admission was crushing to Richard's narrative. It wasn't dramatic, but it mattered. It exposed how small manipulations accumulate into legal arguments. There were costs. Richard filed a countersuit claiming he had been defamed and asking the court to award him trusteeship. He hired a lawyer who painted Eleanor as aggressive. The litigation dragged on for months. I slept with notes under my pillow and learned to breathe while waiting for docket entries. The consequences of all this were not tidy. The audit showed that some funds had been diverted into paying for work on Richard's property and to cover his credit card bills. The independent trustee began a recovery process. Demands for repayment, negotiations for restitution, and, when that failed, a motion to surcharge. Richard agreed to a partial repayment schedule to avoid a lengthy judgment that would attach liens. He offered to return $85,000 over 2 years and to relinquish any claim to the house. He did not voluntarily return the rest. Eleanor counseled me through a settlement conversation. We were practical. The law can take a long time and cost a lot, and sometimes getting a reliable partial recovery now was preferable to pursuing decades of litigation that might, in the end, yield less. I remember sitting at her desk, counting the possible outcomes like beads, and feeling both the bitterness of compromise and the relief of closure. One consequence that felt almost private: Richard stopped coming to family gatherings. He called once, left a message that said he was busy, and then sent a check that was marked settlement. The house remained under the trust, and the independent trustee oversaw repairs and finally hired a contractor that we had both vetted. The independent trustee's job meant no unilateral decisions about selling the house could be made without court approval. The house was not sold. The trust funds were monitored. The distributions resumed at a conservative rate. Emotionally, the recovery was partial. I received money again, paid off the last few months of bills, and moved into a small apartment that I could afford without the trust's assistance. I began working again, at a job that paid less than my old one, but offered some stability. The trust became less daily oxygen and more a safety net I checked every quarter. There were consequences for family relationships too. My sister Tessa apologized. She said she hadn't realized all the facts and that she had been manipulated by Richard's version of events. My cousins divided into quiet camps. Some stopped calling me because they didn't want to be in the middle. An aunt refused to attend the family birthday because she thought the litigation felt public. The pastor who had been called ended up meeting with me privately and said he was sorry he had not asked more questions. The realistic outcome, the court's remedy, and the human fallout were not cinematic. There was no dramatic courtroom confession, no jail sentence for Richard. He repaid a portion of the money, agreed to professional oversight, and was removed as trustee. The court found evidence of breach of fiduciary duty and ordered restitution and costs. It was enough to keep the house and to reimburse some of the diverted funds. There was a small, necessary humiliation in the settlement. I had to accept that part of the trust was used to pay for the legal process. The independent trustee's fees and the cost of forensic accounting came out of the estate. That meant that even after restitution, the trust had less than it might have. It was a reminder that restoring fairness can cost money and that legal systems are not neutral purifiers. They take tolls. After the court resolved the major items, I did something practical. I worked with Eleanor to add further protections to the trust. We created a trust protector clause, added co-trustees for major decisions, required multiple signatures for distributions above a threshold, and replaced the successor trustee provision with an independent trust company if a trustee could not be agreed upon. We documented explicit procedures for sale of the house and for payment of expenses. Those changes felt bureaucratic and safe. They were not cathartic, but they felt like scaffolding. A year after the initial freeze, I sat on the back stoop of the Elm Street house as the contractor finished the last handrail. The house smelled faintly of paint and cedar. There were new gutters and the porch steps were straight. The feeling I had was not triumph. It was ordinary endurance. You do the things that keep you afloat. Call the insurer, schedule the therapy, make the bed. There are private losses that the law cannot remedy. And I lost the easy warmth of family dinners where Richard used to preside and tell jokes that were half invective, half love. I lost the soft assumption that family would always be a source of shelter. I gained, slowly and reluctantly, a carefulness about trust. The people around me now are fewer, but chosen in a different way. They are people who ask questions, who do not assume more than they see. What felt most important was not the money returned or the legal order, but the fact that I had a lawyer who treated the problem as a set of facts that could be compiled and presented. Eleanor had no melodrama in her work. She filed motions, subpoenaed emails, and kept procedural pressure in place until the system corrected an egregious imbalance. Her better plan was ordinary: gather the paperwork, use the law to restore the prior order, and settle where further litigation would be wasteful. The plan was not theatrical, it was methodical, and it worked. A final consequence: I stopped asking for explanations from Richard. When someone abuses a kind of power that depends on others' inertia, asking why often invites more manipulation. He offered a short apology once in neutral email that read like a business memo. I didn't reply. I did set boundaries. No more unscheduled visits, no decision-making without third-party oversight. He complied. Now, the trust stands with clearer guardrails. I have a small apartment, a job, and a schedule of semi-annual reviews with the independent trustee. I still think of the house sometimes, the way light used to fall through the dining room window. I miss small things. But the future feels less like a column of unknowns and more like a ledger with items I can reconcile. If I allow myself a very quiet observation, it is that most betrayals are ordinary before they are legal. They rely on a person's ability to prefer their own convenience over another's rights, and to wrap that preference in a rationale. People who saw Richard as caring didn't change overnight because of a court filing. They slowly adjusted when the evidence spoke. The law was not cadence or comfort. It was a structure that let me point to facts and ask for restoration. I don't want to make the ending tidy. I still think of my parents, and I still miss the casualness of a life before counting receipts. I also sleep better knowing that there are procedures that can be used to block bad actors, and that sometimes a lawyer's quiet, exacting work is what restores a life that has been narrowed by someone else's appetite. If any of this resonates, please leave a like. If you want to follow more stories like this, subscribe. And if you've ever been through a situation where someone close tried to take what was yours, or if you have questions about how the process unfolded, let me know in the comments. I'll read them.